Chief Justice, may it please the Court. To begin, much of my oral argument will refer directly to the submitted case due to its straightforward nature. There is a direct contradiction between the Student Body Constitution, the UF Constitution, and the Student Senate Rules and Procedures. The Court clearly has jurisdiction over this case due to its mandate in Article 5, Section 3B2, to order student government officials to desist from unlawful acts. In Senate meetings, the Court recognized its jurisdiction over Student Government Senate itself as a student government official. Thus, the rules and procedures are well within the jurisdiction of the Court. If the Court's rules permit concrete injury to be satisfied where injury is imminent, the Senate's enactment of Rule 4, Section BDI, makes injury imminent by preventing student senators from exercising a right guaranteed by Article 1, Section 2D. Both myself and all other student senators are considered students under University Regulation 4.0402. On November 18, 2025, I completed all requirements for public comment as laid out in Rule 4, Section BDIII, by emailing the Senate President and Senate Secretaries, expressing my desire to speak and outlining the matter on which I would be speaking. I was denied my ability to speak in public comment. Thus, the foreseeable enforcement of this rule in question moving forward will continue to prevent me from exercising my right to public comment as guaranteed by Article 1, Section 2D. Therefore, injury is directly traceable to me as petitioner. In Rosenbaum v. Brzezinski, the Supreme Court held that a request for nominal damages is sufficient to avoid mootness and satisfy the redressability requirement for standing when a constitutional right has been violated. Therefore, I request $1 in nominal damages in an order under Article 5, Section 3B2, requiring the Senate to refrain from enforcing the rule that unlawfully restricts a right of all students as defined in University Regulations 4.0402, guaranteed by Article 1, Section 2D. I'm a duly enrolled student in the University of Florida under Regulation 4.0402. I'm currently taking 16 credit hours. I was also a duly enrolled student last academic term when this case was submitted during the fall 2025 academic term, during which I was enrolled in 12 credit hours. Both then and now, I served in the student government as a student senator representing the College of the Arts, and I was elected in the spring 2025 general election. As previously mentioned, November 18, 2025, I was denied my ability to speak to the Student Senate, including the 37 off-campus senators who represent me as a student who lives off campus. I fulfilled both requirements laid out in the rules and procedures by sending correspondence to both the Senate President and the Senate Secretaries, and including in my correspondence the topic on which I wish to speak. Specifically, I wanted to give my opinion on a piece of legislation to be heard in first reading at that meeting, SSB 2025-1209. The Senate President responded to my email request by denying my ability to speak, specifically citing Rule 4, Section D. The Senate President went further to encourage me to share my thoughts during the announcements portion of the meeting. However, since the announcements portion takes place after the first reading of bills, the Student Senate had already passed SSB 2025-1209 on first reading, thus rendering my point moot. Because the Senate is a student government body that exercises official authority, and because its rule directly impairs my constitutional right, I seek nominal damages in an order requiring the Student Senate to refrain from enforcing the rule. I've shown imminent, traceable, and redressable injury. I registered for public comment and was denied the opportunity to speak. The injury is traceable to the Senate's rule and redressable through a judicial order of compensation for nominal damages. All requirements for Article 5, Section 3B2 relief are satisfied. The reasoning in City of Madison Joint School District Number 8 versus Wisconsin Employment Relations Commission supports this conclusion. The United States Supreme Court held that public bodies cannot confine participation in public discussion to selected categories of individuals. This rule confines participation in a public discussion to non-senators, barring senators' participation. A rule that permits non-senators to speak but bars senators is inconsistent with the principle that public discourse cannot be monopolized by one group, as is discussed in the City of Madison. Article 1, Section 2D guarantees the right to address student government officials to every student. Student senators remain students under University Regulation 4.0402 and retain all constitutional rights unless a restriction is explicitly provided in the Constitution. No constitutional restrictions are present in this case. The Constitution does not create classes of students, nor does it grant the Senate the power to impose status-based limitations on this right. Thank you, and I wait the rest of my time for rebuttal and or question.
Yeah, I'll start. I understand the text of the Constitution, Article 1, Section 2D says that you guys are able to address, as chief official said, regularly scheduled time and places. And I know you addressed the announcement section and how because it occurs after that, basically what you want to talk about is pretty much ineffective. What if you brought it up in the previous meeting during the announcement section? Would that be possible for you?
In this particular case, and I'll focus on the details of this particular case first before going broader with the issues with the announcement section. But no, this bill was not passed by the Judiciary Committee during the previous meeting, so I had no opportunity to address this particular bill at a previous meeting. There are broader issues with using the announcements period as the designated time for student senators to speak. As mentioned, it occurs at the end of the meeting, which grants its own host of problems. Furthermore, the rules and procedures as they currently exist do not guarantee senators the ability to speak during announcements. The Senate President, a Senate President could choose to not give a student senator the floor, since there are no protections for that. Therefore, student senators are not guaranteed the ability to address their elected officials during the announcements time, and it cannot be used as a substitute for public comment in this structure.
Okay. Thank you. And are you aware of like any other forum other than public comment or announcements where you could get your point across?
Not within the Student Senate. This particular issue focuses on discussion of a specific bill. If I wanted to address other issues other than specific legislation, as could be the case in the foreseeable future, there is zero opportunity within Senate meetings to speak for student senators other than the announcements period, because all other discussion must be pertinent to the topic on the floor of the Student Senate.
Okay. So when, for example, when that bill was announced in the Senate, were you able then to comment on it when it was on the floor? Or?
I was able to comment on it under specific limitations. We engage in pro-con debate. However, pro-con debate has specific rules attached to it, and the Senate President, if the Senate President finds that a comment made during pro-con debate does not explicitly support pro or con of a specific argument, the Senate President is therefore able to rule that, I forget the specific term used, but the Senate President has the ability to rule that speech, I believe, hostile to either the pro or con side, and therefore prevent that speech from happening. Furthermore, if myself or any other senator wanted to give a particularly nuanced position that doesn't fit cleanly into pro or con, as I wish to give to this specific legislation, it would be deemed hostile to either the pro side or the con side, depending on when you're speaking, due to nuance and not contradictory, but statements that don't cleanly align with either the pro or con side.
And then I have a question going off of that. First of all, thank you for coming today. Second of all, and then if you're limited in this way during pro-con, is public comment limited in any similar way when you're discussing a bill, or is it just more open? Is it time limit? Can you just explain that to me?
Yes, I believe there are certain limitations, as are in the case in any public forum. You know, you can't just go up to the public comment podium and just screech and scream about whatever. But public comments are not confined to discussion of specific legislation. As long as it is, again, appropriate for a public setting, you can deliver a public comment on any topic you deem fit.
I had a clarification question about this case. When Senate President told you to, or directed you to speak during announcements, in what way did she say you were not allowed to speak during public comment on this issue, or she suggested that this issue was brought up during announcements versus something else? Like, how did she redirect you in what manner?
She referenced Rule 4, Section B, and stated that student senators are not allowed to speak during public comment.
Okay, thank you.
So, I understand in your in your case scenario, my first question was going to be, for this particular bill, what you were going to say. Can you give me an example of something that would be outside of a pro or a con?
Yeah, so one particularly important thing is historical context. which does not clearly support or negate a bill's passage. The specific bill addressed apportionment of the Student Senate, which has a very long and complex history going back decades, which I wish to speak on. However, simply stating historical facts about election maps does not cleanly fit into supporting the bill or saying, no, we should not pass this. It would fit into a third category outside of pro or con, and therefore I had no opportunity to speak on that.
Okay, that sounds good. The last part is, are you aware of any precedent where this court, not like the Supreme Court or State Court, has awarded monetary damages?
I personally am not familiar with the history of that.
Do you guys have anything?
If you were allowed to serve for public comment, can you still have multiple slots, or can there be
Every student is afforded the opportunity to sign up for one 5-minute long public comment slot.
Okay, do you foresee it being possible that certain Congress or senators could sign up for multiple public comment times to kind of filibuster?
Per existing rules and procedures, that would not be possible since all students are only allowed to sign up for, well, all students with the exception of student senators, as this case outlines, are allowed to sign up for one slot.
What was the original reason for the excluding current students in the college? I know it's the opposite of your argument, but I'm just curious.
Sure. That bill was passed, goodness, about 2.5 years ago. I do not recall the specific motivation behind that bill, but that was a while ago.
Could you clarify real quickly, so you're seeking nominal damages of $1, and then you said in order, can you clarify that part?
Yes, in order that would restrict the Student Senate from imposing this rule due to its unconstitutionality to the UF Student Constitution.
Good. Well, thank you.
Yes, thank you all very much. Thank you for your time.
Yeah, there were buttons. So in terms of the first request relief for the monetary damages and other numbers, I know we can include that for the same issue, but I do think that the monetary numbers may be outside the scope of our jurisdiction as students. But in terms of the second request for relief, I do understand his arguments. He addressed the announcement section thoroughly. That was one of my qualms with it originally. I understand how it can shrink him. He did say that he was actually denied, and the petition said that he was requested it and wasn't pending, was pending. So he said he was denied, so there is an actual inquiry.
I also think part of the thing brought up where people are restricted to signing up for a certain amount of slots, kind of like, it makes sense, right? It prevents that unnecessary filibuster and all that kind of stuff. So I feel like it's a that makes sense without needing to exclude senators from the rule.
You're in the first year, right? I did it for limited designated.
I mean, do you think that, I don't know, it's government. You can kind of be traditional public now.
Right, so I feel like this is the first one membership. Yeah, like pretty clearly, and so they need to show the moral reason why they're sitting senators, and there's no reason.
Well, if you think about it too, like wanting to be like, you know, if there is a problem, like if there is a problem with people not authorizing senators not authorizing constitution for the public.
Right.
There's other ways to solve that
And
problem.
there's a county, yeah, but there's a reasonable.
Yes, it's not narrowly tailored.
Exactly, exactly, it's not.
That's the key language.
Yeah.
So, that's all I have as well.
Alright, so I'll split it up to a vote for the first request for relief and then the second. We're either going to grant or deny. I'll just do the first part and the second part. So, for the audio recording, Grace, we're just gonna say I and then your last name or Justice Beckender. For the first request for relief, I, Chief Justice Amy Turner, deny.
For the first request for relief, I, Justice Social Rosenberg.
sorry guys. I, Justice Gergen, deny.
I want to clarify that it satisfies standing, but then we're gonna deny the remedy, so I also, Justice Miller, deny.
Yes.
Justice Kessinger, deny.
Okay, for the second request for relief, to declare it null and void because it's unconstitutional, we are going to vote or grant or deny. And I'll start, I, Justice Turner, grant.
I, Justice Del Toro, grant.
I, Justice Gergen, grant.
Justice Miller, grant.
Justice Kessinger, grant.
Is it voice recording or they, oh?
He did the voice recording.
Yeah.
They
Oh,
have-
stop, oh, we stop it or we continue it, since we already
I mean, you can do them separately, isn't the next one scheduled?
I'll do them separately, but we can start,
Whatever.
whenever he's ready, because they're not taking this.
And then,
Just block.
Andrew.
So, if-
Thank you for your time.
Yeah, thank you all very much.
You're very great.